Good morning, friends. This judgment which I am going to discuss with you today will definitely help you, the criminal side practitioners, the assistant public prosecutor examination, preparing candidates, and particularly the other judges post examination candidates, because this deals with a lot of question of law and day-to-day problems we are being faced when we prepare a FIR. After investigation, the police normally files a negative final report. Therefore, uh, if after filing negative final report, we used to file refer uh, uh, protest petitions, and the protest petition is being entertained, and after that what all are the procedures, and even after filing our protest petition, the land magistrate if rejects it, and thereafter whether we are entitled to file another complaint, private complaint, on same set of facts or not. This is the ratio was deeply discussed by the Supreme Court. AR 2024 Supreme Court 5690, AR 2024 Supreme Court 5690. Subhash Chowdhury alias Santosh Chowdhury and others. Subhash Chowdhury alias Santosh Chowdhury and others. Here, provisions of 202 173 CRPC was deeply discussed, and finally, the Supreme Court has categorically held that you have got right to file another complaint, but that complaint should have extraordinary circumstances and with additional facts or subsequent facts. Otherwise, that is not maintainable. The maxim nemo debat bis vexari pro una et edam casa, that means no person shall be tried, acquitted or convicted shall be tried on same set of allegations. This was the then they say that was shortly called in two terms: atrophois acute, atrophois convict. This is the two things were deeply discussed. So because it is in North India, the protest petition was called as Naraji petitions. So all these things were discussed. The main thing is they have deeply discussed about various judgment, and particularly you have to go through this judgment, Bhagawat Singh versus Commissioner of Police, wherein AAR online 1994 SC 55, the four directions were issued to the lower court magistrate if the final report is filed negatively. Number one, accept the report and drop the proceeding. Number two, direct the further investigation to be made by the police. To investigate himself or refer the investigation to be made by another magistrate under section 159 CRPC. 4. To take cognizance of offence under section 200 as private complaint when materials are sufficient in his opinion, as if complaint is prepared that course. Then several judgments were discussed, and particularly this judgment is most important, which was a parental judgment for all these cases. That is Samantha Naidu versus State of Madhya Pradesh, AR 2020 SC 2573, wherein all the other judgments were discussed. Judgments are running a little bit more number, but you have to go through the entirety of the judgment. And finally, they have set aside the second complaint taken by the magistrate, despite the fact that first complaint was referred and the protest petition was rejected, and therefore second complaint when taken on file on 202 inquiry, while magistrate dismissing it as not maintainable, was old good. So the question arises, they have held categorically second complaint is maintainable, but it has to be decided if it is same set of facts, so that complaint was not maintainable. This is the ratio you have to understand. I think this is Subhatra Chowdhury alias
Santosh Chaudhary and another versus State of Assam and another. I hope you understand the judgment. Go through the judgment deeply. Young lawyers, go through the judgment deeply. Best wishes.